in the meeting. Okay, we are hot on YouTube. I would ask for a motion. No, we don't do these a lot. So I'd like a motion to resume the recessed meeting from February.
Motion.
Well, from 13 days ago.
13 days ago.
Second. All in favor?
Aye.
I'll probably get somebody to jog my memory from where we were at, but I didn't want to. I did a poor job last time talking about what we were actually doing here. We don't do these very often. But for our ordinance, this has come into play. Roughly, and y'all can correct my numbers if our dates are incorrect, but basically what we're dealing with is around December 22nd, 2021, a permit was issued for work at 106 Stevens Street. February 3rd, 2022, I guess roughly with 6 weeks, somewhere around there. Later, a stop work order was placed. So that rocked on till February of this month, or February of last month, I should say around the 13th, where a portion of the structure had collapsed. And the building department, under the direction of Amy Heath, sent a 7-day demo permit. And that's basically saying you need to come and get a demolition permit. And you got 7 days to do it, to tear the building down. For our ordinance, when someone receives a letter of that nature, they get to come to the board to appeal that, because that was actually a city and an administration action in that case. So anyway, that's kind of where we're at. Someone could jog my memory on the rest of that.
Well,
Or I would ask, I guess, Chrissy, you want to say something?
well, Seth, I mean, I know that you presented a lot of evidence when you were here last, and we recessed so that the board could consider your evidence. I don't know if you had any more, this is your appeal, if you had any more evidence that you wanted to present to this board. I know that Ms. Steele wants to say something, and we may let her say something, get that out of the way. If you had anything that you want to say, we could let you say it, since this is your appeal, and then we may entertain any motions from the board.
Sure.
In regards to what we should do. So,
Super.
do you want to go ahead, or you want, let's hear from Ms. Steele?
I'll tell you what, let's hear from Ms. Steele, and then if she says anything that I think I need to address in the context of presenting anything else to y'all and speaking about what we presented last time, I'll do that.
Sounds fair.
If that's okay with the board.
Yeah, Jack, come on up.
Get this out of the way. Board of Aldermen and Mayor Ducker, thank you for letting me speak tonight. I appreciate it. My name is Jamie Steele, and I stand before you as a Petal resident of over 15 years and a mother to 3 young children. On January 16th, at a public meeting, the building at 106 Stevens Street was condemned by the Board of Aldermen by unanimous vote. A resolution signed by Mayor Ducker stated the property is in such a state of disrepair as to be a menace to public health and safety of the community. A few weeks later, the building did collapse, and the City of Petal sent a letter to Trusted Homes, the owner of the building, that said the structure presents an imminent danger to the residents surrounding it, and it is considered to be an emergency situation. Now, the appraisal that was turned in at the most recent appeal hearing on March 5th, 2024, along with every appraisal that has been turned into the city concerning 106 Stevens Street, has now been turned into the Mississippi Appraisal Board, along with a formal complaint against the appraiser based on unethical manipulation of property evaluation. But regardless of the Mississippi Appraisal Board's ruling on this matter, we can all clearly see that the appraisals are invalid and they contradict each other. I provided all of you a summary of the appraisals that we've received, or the city has received. But taking the appraisals out of the equation completely, in this manipulation of this numbers game that we've been a part of for a long time now, the building at 106 Stevens Street is built so close to the property line, arguably on the property line, that is clearly a non-conforming structure. Ordinance 9.36 in our Petal Code states, when a non-conforming use of a structure is discontinued for a continuous period of 1 year, the structure shall not thereafter be used except in conformity with the regulations of the district in which it is located. The last business at 106 Stevens Street was Deep South Cycles. I gave you a copy of the most recent license of privilege. That's from 2017. This building has been vacant since then. So that means that the building needs to conform with our ordinances. The property at 106 Stevens Street is currently zoned C2 and abuts an R1 property. That's my home with my 3 young children residing in it. The structure at 106 Stevens Street, let's see, no buffer zone requirements are met the way this building is built. We have these buffer zone requirements for privacy rights of our citizens as well as for structural and fire safety reasons, and my home and my family should be protected by these ordinances. I'm asking that the Board of Aldermen deny this appeal and continue on course towards ensuring the safety of Petal residents by demolishing this hazardous building. Thank you for your time and your service to our community. Does anyone have any questions for me?
Do you know that a building can be built there?
Yes,
Okay.
as long as it is built to code and follows our current ordinances. Yes, of course it can be. Anything else? Thank you for your time. Thank you for letting me speak tonight.
Thanks, Jamie. Seth,
May it please the board. Last time, before we got started, I'd asked Mr. Steele if he intended to sit in on these deliberations as he is a neighboring property owner. I'm gonna ask the same question. You intend to sit in, or we would ask that you recuse yourself, but you
I'll be
intend?
really clear about the purpose of this meeting, and it's not to address me in that way. The purpose of this meeting is to provide any additional evidence that you have to this court concerning 106 Stevens Street.
We're gonna move that you recuse yourself from these deliberations as you are a neighboring property owner. Are you gonna recuse yourself from these deliberations?
We're not gonna have that discussion. Do you
We've
have
got-
any additional evidence concerning 106 Stevens Street?
Sure, I've got some documents I want to enter into the record in this matter. And first off, Mr. Steele, I think last time we were aware that you had one piece of property directly, looks like north of Trusted Homes, the Trusted Home property, 106 Stevens Street. And I think that's 110 Stevens Street. That's you and your wife's home, is it not?
I'm not really going to discuss in this meeting my assets.
And then across the street, and I want to apologize to you, I got it wrong last time.
I'm sorry at this point.
You have 6 pieces of property across the street.
I
This
would
is
say-
irrelevant.
We didn't interrupt Jamie, and it's his appeal, so I'm not interrupting him. If you quit interrupting him and let him finish, please.
Do you have 6 pieces of property across from 106 Stevens Street? Yes or no question?
I've already explained that I'm not being concerned.
Are you the owner of 117 Stevens Street? Excuse me. Are you the owner of Steel LLC?
So once again, that is not the purpose of this property here.
Are you the owner of 117 Steel Street through Steel LLC? Yes, no? Are you the owner of 115 Steel Street, or 115 Stevens Street through Steel LLC? Are you the owner of 109 Steel, or 109 Stevens Street through Steel LLC? You refuse to answer these questions?
We're not here to answer those questions today. We're here.
I've got some documents I want to put in the record. First is a copy of a certificate of formation for Steel LLC, which lists Gerald B. Steele and Jamie M. Steele as managers of Steel LLC, with a business email address of Gerald Steele of petal@gmail.com, registered agent Gerald B. Steele, 110 Stevens Street, Petal, Mississippi. Have an overhead map showing all the property around 106 Stevens Street that Mr. Steele owns. I've got copies of the deeds for 110 Stevens Street, 109 Stevens Street, 115 Stevens Street, and 117 Stevens Street. 110 is owned by Gerald Steele and Jamie Martin. I think Miss Martin Steele, who just spoke to you. And then 109, 115, and 117 Stevens Street is owned by Steele LLC. I'd like to make these part of the record.
Just have the one copy.
Yeah, I did my approach.
Yeah, we could just give that to Melissa if you wouldn't mind.
Mr. Steele, are you going to recuse yourself from these deliberations?
No, I'm gonna ask you to get to the point as far as 106 Stevens Street.
I've gotten to the point of asking you to recuse yourself. Are you going to do that?
What are your grounds to ask him to recuse himself?
Mr. Steele, you would agree you have pecuniary interest
No,
in what occurs at 106 Stevens Street, wouldn't you?
no, sir, I don't.
Right.
And in fact, I would say that the development of a building there and repairing that building would actually be the things that I would stand against if you could even make that argument. But I don't think that that is a legal argument that one can have according to my conversations with the AG office and with the ethics board.
Who'd you speak with at the ethics board?
I'm not going to continue this conversation. I would like to know why you're here tonight. We're talking about the demolition of 106 Stevens Street.
Who did you speak with at the Attorney General's office?
I've made it clear I'm not going to engage in this one.
Did you agree with me that you did not disclose any of these
Sir, we are
conflicts
not
of
here to do
interest
this.
at all to anybody before this last meeting when I had to confront you about it?
I'm sorry, I didn't even hear that question, but I don't think I need to.
Sure, I'll ask you again. Do you agree that you do not disclose your conflict of interest in this matter until the last meeting where I asked you about it?
We're done.
You don't agree with me? Or you do agree with me? I mean, yes or no, did you or did you not disclose the conflict of interest before the last meeting? You didn't disclose it then either. I had to disclose it for you, correct?
There is none.
I'd like the record to reflect we've asked again for Mr. Steele to recuse himself, and he refuses to do so. At the last meeting, we presented several documents. The first of which I think was requested was a February 29th, 2024 document. Jim Cox, the appraiser, gave an appraisal value as of January 7th, 2022 for $85,000. The other documents were a report from Pittman Engineers, Jeff Pittman, about the work that needed to be performed at the property to bring it back in to code and bring it back into usefulness. And then also we presented 3 estimates, just to go over these again because I don't want anybody to be confused. One was an estimate that showed a number of $40,727.83. That's what I want to call the all-in estimate. That's the work that was performed before the stop work notice, which was $10,750. And then the balance that still needs to be performed was $29,977.83, which was the second number. And then finally, just one invoice for the $10,750 that was performed before the stop work notice came out. So those are not cumulative. They all have a purpose in why we presented them. Those were all from Mr. Stabile's company, Trusted Homes LLC. And I think, obviously, it's important perhaps maybe to get somebody else to give an estimate in this matter, because maybe have a third person look at this and say what it's going to take to bring the business back or the building back to where it needs to be. And so we went out and we got another estimate from Specialty Construction and Restoration LLC, prepared by Chip Hill, who's here with us tonight, to give an estimate of the work to be performed. If you'll hand those out, please. Including the work to be performed pursuant to Mr. Pittman's February 20th, 2024 report to get the building back into, I think, what would be a habitable condition or a useful condition. And Mr. Hill has given an opinion, a statement that the construction cost, and he listed on here on the first page what needs to be repaired from this point forward. And the total cost is $31,500. Now, I think one important thing to notice in the flood statute is that if a code violation is alleged, then and you have to do some repairs to a building to bring it back within code, then that number is not included in the total value. Let me find that statute. Let's see. Okay, under the City of Code ordinance from 2018, ordinance 2015-135A1, substantial improvement states that that term does not apply to any project for improvement of a building required to comply with existing health, sanitary, or safety code specifications, which have been identified by the code enforcement official and which are solely necessary to assure safe living conditions, provided that said code deficiencies were not caused by neglect or lack of maintenance on the part of current or previous owners. And one thing we pointed out last time was that this roof collapse that occurred because somebody went into the building and pushed over or pulled out some of the beams that were in the building and caused the roof to collapse. And
That's
again,
completely
there's a police.
speculation, and we
If
actually
you
have
could
doc-
interrupt in our meeting, ma'am,
There's a police report that Mr. Stabile has filed in that regard. And so anything in these reports that have to do with repairing the roof collapse, which is the reason that the code enforcement officer issued a citation or issued I don't want to call it a citation because it isn't,
demolition.
issued a demolition order was because of this roof collapse. Well, if you take out the roof collapse, I've spoken with Mr. Hill, a substantial portion of what he has posited needs to be done to the building, repaired to the building, is because of this roof collapse. And so you really should not take that into account. As a matter of fact, about 50% is putting the roof back up, according to him. So you should not take that into account when looking at those numbers. However, taking into account the number that he's provided, $31,500, that still falls below the 50% flood threshold in this case, in this matter. So I've got Mr. Hill here. If anybody would like to ask him any questions. Mr. Pittman, the engineer, came back again today. If anybody has any questions for him, because certainly this has been a long road, and I think last time, like I called it, a continuing conversation because it is. But we would like at some point for Mr. Stabile and Trusted Homes to be able to go over there, do the work that they've been stopped from doing for 2 years and put this building back into a usefulness as opposed to sitting there and not doing anything and apparently not making the neighbors happy. So we'd like to make the neighbors happy, bring this thing back into compliance and move on with the matter. But I've got Mr. Pittman here. Again, if anybody wants to ask him any questions, we're certainly happy. He's happy to answer any questions.
Sure. Any questions from the board for anybody?
Well, Jeff, I'd just like to clarify, and looking at your analysis and tying into what Chip has prepared for us. you talk about the construct a new roof system to include adequate columns adjacent to stud walls. You're not recommending use stud walls, and like I said, adequate beams. And bottom line, you talk about, the floor, the concrete floor and the depth. You laid out pretty clear in this, so, basically saying that in order to rebuild the roof, you have to basically have adequate structural design foundation for those footings. And Chip, that's what your report takes into the cost estimate of doing that properly?
Yes, sir. And it mentions Jeff's report on my proposal.
Yeah, and I just want to make sure that's a clear linkage.
Yes.
Normally, and I'm trying to draw comparisons to try to be consistent of what we've done for other buildings. We currently have the library condemned for a structural issue.
The old library.
The old library, not this. Yeah, don't give me trouble.
Greg got me on that earlier.
So, that's condemned for a structural issue because of a structural issue, which there's a structural issue in this building. Is that what, based on your report, there's a structural issue currently because there's no roof?
Right, yeah, the
Right.
roof, and then of course what was out, some of the decay in the studs and all.
But like I said, it's like anything construction, you can fix things.
Oh, yeah.
with enough money and time.
If a person has the time and the money, they can rehab most any building.
So like I said, just as I draw comparisons with what we're doing, because we've asked them the library to come back with us and says, hey, here's your drawings to make it a plan. Here's the plan, yeah, because the stamp plan, right? I mean, I think not to draw another comparison, but we're still waiting on those stamp plans from that owner. And so that's another separation. But again, we have a process where we're trying to execute, we're trying to make a safe facility. So it's there for 50 years or 100 years, however long. And that's so as part of this plan process, and what I understand would be moving forward is if there's a building permit authorized, would be that our normal process would be where we would actually stamp architectural design for structure. And is Amy here?
Yeah, she's done.
Okay. But again, there's a process to make sure, because we're doing
There's
it.
a couple, and Amy's mentioned that there's certain inspections that Mr. Pittman could do instead of our building department. And a lot of times we do that when there's an engineer involved. And so we've got to propose a building permit, and that's her proposal. Was to have Mr. Pittman assist on that.
And I think what Mr. Beal said, there are some stamp plans already turned in to Valerie Cameron.
Valerie Cameron made them. She did they were done twice, so they were done exactly as asked, handicap bathroom, bigger doors, all kinds of stuff. So I spent a bit of money to get them done right. Valerie Cameron did them, turned them into Amy Heath, and she was pleased with them. And that I was told originally, if I got those plans, I'd get my permit. I did that, but then it's almost like the bar kept moving.
But just go back, like I said, those plans might not be relevant now because of a structural issue. That's why I kind of draw an issue with the other facility. Now we identify there's a structural issue, we got to make sure it's done properly. And like I said, that's
I get what
the
you're doing.
process. And that's what, but it sounded like I said, Jeff, based on your analysis, that there's a requirement to structurally fix the building.
Right.
But it's doable based on your
Right.
engineering design, engineer opinion. And then like I said, Chip, your $31,700 addresses all those structural issues.
Yes.
And you're able to do that without a house design plan? Without, usually a lot of times I'm trying to link up without a plan, a design plan. It's kind of hard to say, because you don't have plans for what's going to be there. Or do you have plans? You're given the old plans that,
Yes, well, the structural issue that Jeff addressed would be the same regardless of what you did with the layout of the floor as far as the plans are concerned.
but the original, the house plans or the plans that were submitted way back in to Amy, to our building department, did they address the structural issues of the walls?
Yes,
Okay.
the original plans we were always intending to put in new supports and new beams on that middle area.
Okay.
So, that was always the plan, and in all of my applications for a permit, that was work that was planned to do. Now, once the pillars were removed and it fell in that center section, now, obviously, we're starting over on first rebuilding the roof right there. And when we do that, of course, we're following his instructions to cut out the cement, have deeper foundations, nice solid Packards and framed in, and, new beams and, I'm actually, as the owner of the building, I'm actually, it's nice to have it be brand new in that section. I'm trying to keep a positive attitude.
Again, I've already spoken about structural just because I'm trying to relate it to what my experience with our process with another building. And like I said, we haven't been provided the board those plans. Because again, that's part of the process, and that's day-to-day activities that we don't normally get into at all. So
Do those plans address the elevation of the building?
I can't answer that question.
Do those plans address there's two routes to go. You either build above the floodplain or you build with the waterproofing process, which is a very thick and expensive book. Not the book, but the process. Does it address that, one of those two?
All I can say is the plans that I was asked to get, the first set, they asked me to have Valerie Cameron make them. When I turned them in, they were approved, okay? And they said the plans were great. Then the issue
Who's
shifted,
that?
the Amy Heath, and then it shifted at that point to just talking about the budget as it relates to it being in the FEMA, 50%. And so,
Okay.
but
I think, I'm satisfied knowing that.
And those
Yeah, you
plans were
talked-
turned in when? Just clarification.
summer of 2023, I think. I'd have to
Okay.
check my
So
date.
those are the plans that we've had access to and have seen. They do not address elevation. They do not address waterproofing or being able to build in a flood zone. They don't address any of those concerns.
May I say one thing in regard to what he's talking about?
Please.
I don't think you need to. I think if you just hold off for just a second.
Now, I appreciate, like I said, I just want to clarify, like I said, the CHIPS addresses the structural foundational issues. If that was according to the original plans that was submitted, and if it's approved by our building department, that's part of the process.
Drew, my concern is that when you're building in an AE flood zone, that process is much more detailed and for good reason. We have to report, to higher government, like the way we do that in that flood zone. And by not doing that, that puts the entire city in a difficult situation if we ignore those ordinances. Guys, do you mind if I do my thing? Because I'd like to share. I'll make it as short as possible.
I just want to, I want to make sure, I want to know, my injection was asked about the structural portion with Jeff, because I know you're here. I don't want to interrupt
That's the two things I
Seth's
wanted to know.
process of the appeal, because like I said, it's my first one, so
That's okay.
I apologize.
Well, is any, besides Drew and Gerald, is there any other alderman that had any questions?
No, you answered mine.
Seth, is there anything, I know that you want to say something else, Gerald, and I guess we can let you say whatever you want. But why don't we let the folks who are presenting their appeal, see if they had any bit more evidence that they wanted to present to us before Gerald had his say.
No, I think we presented everything and presented documentation. If the city would like, I've got a copy of one page of the police report, but not the affidavits. If the city would like for me to supplement with the affidavits from Mr. Stabile and Laura Ventura, who filled out the affidavits regarding what happened over there, I can certainly supplement that. But short of that, I think we provided the appraisal, the estimates to repair in compliance with the code. We just asked that the city make a vote and determine that Mr. Stabile and Trusted Homes are entitled to the permit to get back up and running and get this job finished and going. Thank y'all for your time.
Go ahead, Gerald.
So I just want to be real clear. My name has been brought up in this meeting several times. I do want to be clear. I am an alderman and I do own property in the ward I live in. And the city has done work in and around those properties. I don't think that I'm not allowed to ask for a road to be paved, just because I own property in that area. I don't think that that's a violation. I don't think it's a violation for me to invest in this neighborhood that I call home, or to be concerned about my home or want the very best for my home. Before I get into this, and I have a little thing I'm going to read off for a minute here, but I want to be really clear that I believe Trusted Homes can rebuild this building, but it has to be done properly. The current building does not meet what I've been calling the 50% rule, because it is a substantial improvement. And in our ordinance, that is 5.72, and also repeated again in 9.22 of our ordinance. And it basically says that once the building begins, once you start building, that you can't get an appraisal after that. Like the value of that building must be determined before anything is built. And we know we were provided with an appraisal on December 20th of 2021 that clearly says that its value is $35,000. And that is the first appraisal we got, and it actually made it. It's also a non-conforming building. And 9.36 clearly says 1 year of inactivity and a building loses its grandfather clause. And to be built, it needs to be brought up to code. And so that's two things. That's two things in our ordinance that say this building is not eligible to be rebuilt. It's a substantial improvement. I'm sorry, if anyone drives by that building and disagrees that this needs substantial improvement, that's a problem. I think that it screams that I need a lot of work. And it's over that 50% line based on that appraisal we were given. The nonconformity thing is really important because it doesn't conform in so many ways. We have the National Building Code. There are so many violations in this. We've had Bill Rogers look at this property in 2016, I believe, 2016. And he, in his report, said there are too many violations to even list here. And he lists a whole bunch of them that haven't been addressed. And that's just being ignored. So the reason that we have these ordinances that basically say this building is not eligible to be rebuilt, the reason we have those rules is for safety. And this situation actually shows us why we have those rules and why they're for our own good. Well, first of all, this building has collapsed. And if anyone has taken the time to drive by that building and look in the building, what you'll see is that the part that has fallen in is made of new rafters, new support beams, new plywood, and new shingles. It's bright yellow wood that was put in after Trusted Homes purchased this property. The shingles on top of it are all new. And we've seen a slow progression of that nice new wood that was recently installed in the last 1.5 to 2 years fall in. And the reason it fell in is it was attached to rotting structure, and it fell in. If we hadn't stopped this, that could have fallen in and been a very bad situation. These ordinances here are to keep not just the neighbors safe, but anyone who goes in that building, the public, our citizens, and people who visit our city, your families. It's there for those safety reasons. You can go right now, look through the window of that building and see that bright yellow wood with brand new shingles on top, brand new plywood on the ground next to rotted wood. It literally looks like mushrooms are growing off of it. It's so rotted and mildewed and decayed. And that did not happen in a short time. That is a decade of rot. That's why the building is not safe to be repaired, and that's why we have to follow these rules. They're there for a reason. Basically, Trusted Homes can build a building there, but they have to follow the rules. And right now, they're not following the rules. They're spending a lot of effort to get around the rules. There's been electrical work done in that building, structural work in that building, and the layout has changed. And all of those things were not permitted. All of those things definitely happened after Trusted Homes LLC purchased that building. And we did that without permission, without proper professionals checking off on it and saying this work is okay. It was done in a sneaky and underhanded fashion to get around our laws and rules. The appraisals, I hope y'all are seeing these appraisals. If you pull out the thing Jamie gave me, mine looks a little silly next to hers. But if you pull out the one, the first appraisal was 35. And then we got a progress report that said, based on the work completed, it's worth 71,000 now. And then the next appraisal of the same year, the second appraisal for 2023, they said the work is 47% complete. Now, mind you, this is unpermitted work that wasn't supposed to be done. And it added how much value to it? It's $80,000 now. And then we got another appraisal just recently to us, in February 2024, that says the property is now worth $85,000, but it's backdated to right after the first appraisal. So in a matter of 17 days, that property went from being worth $35,000 to $85,000 in 17 days. And somehow, the work that hasn't been done yet to add that value has skipped back in time to that earlier appraisal. So how is the work that's not even done yet? Because we can see right here, there's a progress. The progress report added that value. That value was 47%, $80,000. And then let's put that $85,000 now back in time to 17 days after that first appraisal of $3,500. Well, the board that reviews appraisals was surprised by that. And that's something that's outside of this conversation, but the fact that raised concern, huge concern. I wrote a quote down here, but I'm having trouble finding it. But they were deeply concerned with that. And to me, I don't think we needed an outside board to tell us that that is beyond shady. That is Trusted Homes hiring somebody to produce what he needs and ignoring whether or not it's accurate information or not. Our original appraisal of $35,000 seems to be the only honest appraisal we've received. Everything else was based off of unpermitted and illegal work, which eventually led to the collapse of that building. I think that is substantial information and something that should be considered. FEMA came and spoke to us directly, and I directly asked her some questions. And she answered all of those questions. You guys were here. But I asked, can a board of aldermen grant a variance on a FEMA regulation because the buyer's paid a large amount of property in an 80 flood zone and wants to rebuild it? No. What if the buyer stands to lose a substantial investment? It doesn't matter. What if the buyer has already substantially improved the structure without a permit? That's their problem, not her, what is mine. What if the permit was already given? The permit should not have been given. What if the buyer substantially improves the building and then brings a new appraisal that includes the new work of the appraised value? No, that would be unacceptable. Once that first permit was given, that first appraisal was given, the answer was cemented in stone according to our rules and regulations. We should have been done at that point. Can a variance be issued after the fact? No. It has to be done before the work. And then, of course, she went into all the fines and penalties that the city would face if we were to ignore those variances and not follow the contract that we agreed to, this Board of Aldermen all agreed to, follow this agreement with the federal government in order to receive money. We agreed to that as a group. And if you recall, I said, I'm going to hold you to it. So I want to also tell you, and I'm almost done here, I also want to tell you my time in that building. I worked in there with Eat South Cycles, and the city did not allow public entry into that building because it was unsafe. The city denied our permits because we had to fix everything and bring it all up to code or nothing. And that's why when Bill Rogers' report, which is included in the packet, in 2016, he came and he listed all these things that needed to change. And it was too much. I became aware of all the problems. I became aware eventually after asking enough questions and pushing, I became aware at that time about the 50% rule, about the non-conforming rule, because this is what I was told by the city, why this building is ineligible to be rebuilt. I don't understand what's changed now except for a lot of rot, a lot of work that shouldn't have been done, and what seemed to be some bad investment choices. Deep South Cycles actually moved out of that building at that point, and the building has been empty ever since. The building that the public, it's not safe enough for the public to enter. The building that no building permits could be issued for unless it's brought up to code. All of a sudden, we're talking about or considering doing something else. And I'm very confused by that. I'm very confused by that, especially when all I'm asking for is that we follow the rules. The rules are clear. This building is not eligible to be repaired. It is eligible to be demolished. Trusted Homes LLC is able to rebuild a building there if they do it correctly. I see a lot of people in this room who are getting paid to say what needs to be said to help Trusted Homes LLC. We have a stack of appraisals that are some of the most suspicious literature I've read in a long time. That is a clear attempt to cook the books and get around these rules. These rules are for our protection, your family's protection, our city's protection in so many different ways. We've heard from Nima. She didn't stutter. She was very clear. This could affect the entire city, not just the neighbors. It also affects everyone who ever goes in that building. This is our chance to remove that building and have a proper and safe building put there. Okay, I'm good.
All right, do we have a motion from anybody on the board?
Will there be an opportunity for public comment?
No, sir. This is not that kind of.
This is a public hearing.
It's not, that doesn't mean there's a public comment section. We've already heard from a neighboring landowner. That's all we need to hear from.
I'm a neighboring landowner too.
That's all we need to do.
It's actually an appeal hearing for them, so it's not really done like our normal meetings are.
Okay. I
In
see
that
how that-
regard. This is their opportunity to
Can you?
make their case to the board.
Can I make a motion to hear them if anyone will second that? I think hearing from the community is important.
Really?
It is a public hearing and we'd like to hear from the
It's,
voters.
it's not, it's an appeal.
It's an appeal.
It's not a public hearing. We're ready to vote on having the appeal hearing.
Still a public hearing. It's a public hearing.
All right, based on the motion, I'm gonna move to grant Trusted Homes appeal. We're gonna reverse the demolition process and issue the building permit. That's the motion.
Do I have a second?
I'd like to amend, I'm not comfortable with the building permit that you, unless, I mean, did Amy draft that for you?
She did.
Yeah, there's some aspects of, I mean, I just, about the structure, I wanna make sure it's covered in that. Like, in the way that it's written, it didn't sound like, and it might be, it's, when I saw that, and I was hoping she'd be here, because I mean, I want to ask her some direct questions, so I'm fine, just,
How about his motion, but with the building permit, to be issued in the next 30 days?
according to our process. Yeah.
I have some questions about that because I haven't seen the building permit. Is that going to address the concerns of the neighborhood? Is that going to address the setbacks? Is that
It's been drafted. Yeah,
Yeah, it'll go through our,
and it's not even, it's what we're gonna use now because we're in limbo.
are we going to?
Because we wanna get these details
Oh,
that you're talking
yeah.
about. That's what I mean.
Yeah,
Is this going to be rebuilt to code? Like,
So you're amending your motion to basically grant the appeal
not to tear it down.
And to do away with the demolition permit and then to issue a building permit within the next 30 days in coordination with our building department. Is that your amended motion?
Because that's the two things they went around on, right?
Yeah.
Yes.
And do we need to revoke the letter that we sent out that said they could repair the roof without a permit? Did that go out?
No, that meant, and that was just temporary repairs, no.
No, it was allow them to repair the roof. It didn't really specify.
I don't think we need to do all that. think we're just
Yeah, I don't
here
think they're
on
gonna
the-
temporary repair of that.
Yeah,
No.
we're just-
That'd be silly.
yeah, we're just here on their appeal.
Okay.
So I think
We're
that,
here on the two things.
well, they provided the two
Yes,
things that we
yes.
required, yes.
So,
But we're
so,
here on the appeal,
so we're just accepting that appraisal. Like, this board is gonna accept that appraisal.
yeah, we're not questioning the appraisal. Y'all file complaints with the appraisal board and it's cleared up to our reading that you have not looked at the correct definition of what an as-is paid price versus market value price is, and that's in those appraisals.
The as-is
and
is,
so,
is
yeah, we've
what
made
we
our
need for our
decision in that
ordinances,
regard.
is the as-is price.
Yeah, That's our
And we
ordinance.
had, so you had a second, is that right?
Did we do the amendment?
Yeah.
I didn't want to
We
do it.
got motion to grant Trusted Homes appeal, rescind the demolition order, and grant a building permit within 30 days.
Okay, so that's his
Language
motion.
should be cited.
Yeah, language that
As
make sure our
stated.
process is followed. for
That
for-
appraisal went up by $50,000 while no
You're
work was
seconding
getting
this?
done.
So we-
How are y'all
Got a motion,
accepting
got a
that?
Second, all in favor?
Discussion.
Okay.
I would say this, I would say that the second appraisal kind of did a lot for me, because that was one of the things that I was concerned about. Rocky, would you feel comfortable at all addressing some of the concerns that Gerald has brought up? I just want a conversation about our situation with MEMA and FEMA. I want to know that we're in the good in that. I want to know that that's not something that's going to come back and bite our residents.
I mean,
I think it's going to wind up in front of them.
I don't know how it winds up in front of them, and if MEMA wanted to be here,
Okay.
this meeting's been known about for almost 2 weeks.
I spoke with,
Do you want me to answer the question? Or
Yes,
do you want
I
me to be interrupted continuously? So as far as the estimates, I've talked to this board, except Gerald, that there's a difference between what an as-is and a cash price basis is in an estimate versus a market value. So that can explain some of the differences in these appraisals. And we're not in a position to judge the appraiser. That's something independent. All we've got and all we know is that they've complained to the appraisal board, and the appraisal board has acknowledged their complaint. The appraisal board didn't tell us to stop this hearing, or that we should not rely on any of the appraisals. And as far as I can tell, when looking at the wording of the appraisal, they've not really raised a valid concern when you actually look at the language in the appraisals and where the appraisal distinguishes between the two values that it's given. Even in the very first appraisal, there's two different values. There are two different values that are discussed in the appraisal and in the quote letter from the bank. As far as the flood statute, we initially stopped work and then requested more documents of Mr. Stable and Trusted Home based on the flood ordinance. So this city has always had two requirements for Trusted Homes based on the flood ordinance, and we cited to the flood ordinance. And that's what they provided, because they've now provided what we requested. That forms the basis for my opinion that, yes, you should grant their appeal and give the building permit. So I think that addresses the flooding concerns. Now, the non-conforming is not really part of the that's not part of the flood code, that's part of our zoning code. And technically, when properties sit fallow for a year, then some of those restrictions or some of that grandfather should come off. But we never, when we stopped the building permit and all of that, never have we used that as a basis. We can't now come in after the fact and say, well, even though you've now given us the two things that we requested the entire time, we want to now look back at the building code, or at our zoning ordinance and find some other place where we can get you. And if we were gonna get him on that one, we should have got him on that one when he bought the place, or really in 2016 or 2017. But by the time this thing was sold and this guy comes to do a building permit, we're not tracking, we don't have a master track of, listing of properties within the city where we're tracking everything possible that could be wrong or that somebody ever said was wrong. There's just no way for our building people to know whether this had been or was not in conformity for the last year. So when this building department got a complaint that there was work done beyond the scope of the building permit, a stop work was issued and has never been picked back up. And we've been in an appeals process since then, of one or another. We've now come to the final appeal. It is time to move on. We've talked about the issues that Gerald's raised among ourselves. That's how I address his issues. Most of what he cited to is inapplicable. And we've dealt with the two things that we've requested of them continuously. They provided, and that forms the basis for my opinion, that you should all vote in favor of the motion that is currently before you.
And to keep my family in an unsafe position that you have all been made aware of. My family is in an
Got a motion and got a
unsafe
second.
position.
If you would, by show of hands, all in favor? All opposed? All righty, so we'll work out the kinks over the next 30 days for the language, and I would ask, is there a motion to adjourn this meeting? Is there a second?
Second.
All in favor?
Um,